Straight ahead on Law&Crime Daily. Half of the so-called Doomsday duo is back in court.
One is up to life in prison or death. Do you pick the higher one? Do you pick the lower one? Does it matter? Do you pick both? Could they run consecutive?
Lori Vallow Daybell's response as prosecutors discuss a potential sentence. And
I feel horrible because I can't help. I can't help find my wife because of what they've done. And it's this thing I want to. They told me to shut up, and I can't shut up because I'm just trying to find her.
The Matthew Moore trial begins in Ohio as he faces murder charges after allegedly staging his wife's 2020 death as a suicide. Plus, the Parkland school shooting penalty phase trial.
I believe it's your decision to decide where I go and whether I live or die.
Does the defendant understand the terms of his future sentence? And later, the Vanessa Bryant lawsuit against Los Angeles County. Hear from a Law&Crime Network reporter from inside the courtroom. Law&Crime Daily, covering court cases from coast to coast. Welcome, everybody, to Law&Crime Daily. I'm Jesse Weber. Lori Vallow Daybell, half of the so-called Doomsday couple, was back in court Tuesday ahead of her trial. She and her husband, Chad Daybell, are charged with murdering her children, Kylie, Ryan, and J.J. Vallow, as part of a religious pact. Law&Crime's own Anjanette Levy's here with what happened in court. Anjanette?
Well, Jesse, this was actually the second time that we've seen Lori Vallow Daybell in a courtroom since she was deemed competent to stand trial and returned to the county jail. Now, her attorneys are arguing over some technical details, including how the word conspiracy is used in the indictment charging Lori Vallow Daybell with murder and grand theft. Prosecutors believe Lori Vallow Daybell conspired with her brother Alex and her husband Chad to murder the children for their Social Security money. Rob Wood argued that you can have a conspiracy to commit multiple crimes. He's the prosecutor. But Vallow's lawyers do not believe conspiracy should be added to both the grand theft charges related to the allegation about the Social Security money and the murder charges to make it less confusing for the jury. Attorney John Thomas believes that indictment should be sent back to the grand jury and have the grand jury split those conspiracy charges.
Your Honor, in closing, I would just say to the court, and I know that the court is well aware of this, that a person's life is on the line. The prosecutor for the state of Idaho represents the interests of everybody in the state, and that includes the defendant. They are duty-bound to look out for the procedural interests of the defendant, and what they're arguing, in my opinion, Your Honor, is wrong. The state's attorneys here are here to seek justice, not just a win. And they're here to protect the Constitution and the rights of all those in the state of Idaho.
Now, the judge did not decide on this issue during this particular hearing. He said he would take it under advisement. That means he will look at it and issue a decision later. And if Lori Vallow Daybell is indeed found guilty of murdering her two children along with her husband, if she's found guilty of conspiracy to commit murder, the maximum penalty she could face under the law is a death penalty punishment. Jesse?
All right, thanks, Anjanette. So joining us today is former senior homicide prosecutor Bernardo Villalona and Los Angeles County Deputy Public Defender Philip Dubé. It's great to have you both here. Philip, I'll start with you. I have to say, I thought it was an interesting argument about sending the indictment back to the grand jury, separate the crimes into different counts, that this conspiracy language is confusing. What was your take on it?
Well, first of all, defense counsel doesn't have standing to dictate to the grand jury or to the prosecution what charges to bring. If the indictment on its face is defective, you bring a motion to set aside various counts in the bill or set aside the entire indictment. And thereafter, if the prosecution wants to re-impanel a grand jury or seek a superseding indictment, that's fine. But having said that, each separate crime involving a conspiracy has to be alleged and proven separately. So if it is conspiracy to murder, you need to prove that beyond a reasonable doubt, along with the overt act as well as the theft-related offense.
Bernardo, I don't know if you caught this, but at one point the prosecution, they discussed the possibility of life in prison or the death penalty, and Lori Vallow Daybell could be seen smiling and laughing, and I'm wondering, could something like that bring her competency back into question?
So Jesse, let's not forget why they called it the Doomsday Cult Killers. In this case, remember Lori Vallow and her husband Chad Daybell Vallow did not believe that they were going to live past the doomsday. So they're even surprised to be alive right now. But aside from that, when we're dealing with competency, her laughing or smirking wouldn't be a red flag to me. What we need to understand, is she competent in the sense that she understands what is going on, what are the roles of each of the players inside of the courtroom,
Right.
and whether she can assist in her defense. She was found not competent to proceed before and has been now cleared to proceed. So the question would be from the defense attorney whether they believe that she no longer is able to assist in her defense, which will bar the prosecution from going forward. But
Right.
a smirk and a laugh is not going to do it.
Well, it's chilling, and Jeanette, we got about 30 seconds left. Tell me, what is next in this very complicated case?
You know, Jesse, it is a really complicated case and also a very disturbing case, of course. Chad Daybell and Lori Vallow Daybell, their trial is tentatively set for January. There was an effort to have those cases severed, but the judge did not grant that request. So we're looking toward most likely a trial in January of 2023. Lori Vallow Daybell, I'm assuming we will see her in court along with Chad Daybell before that time.
And we'll continue to cover it. And Jeanette, great reporting as always. Moving over to California, there's still no sign of missing teenager Kiely Rodni, as officials say they soon plan to scale back the search for the 16-year-old. Now, Rodney was last seen in the early morning hours of August 6th at an end-of-school party at a campground near the California-Nevada state line. Officials say her 2013 Honda CR-V hasn't been found, and her phone has been without a signal since that morning. Local and federal officials have spent thousands of hours following up on more than 1,200 tips, but all of them have led to dead ends. Surveillance footage 6 hours before her disappearance shows the teen wearing a black spaghetti strap bodysuit, green Dickies pants, and black Vans shoes. Officials say they've confirmed Rodney was seen at the party wearing a white hoodie covered in the phrase "Odd Future" in pink letters. In a press conference late Monday, authorities said no tip is too small to reach their ultimate goal of finding Kylie.
Our search for Kylie continues, and we're trying to do the best that we can to keep things moving in a positive way and attempt to find some clues and locate some idea of where we need to get to. We are still looking for any clues, videos, tips, any information to help us to put pieces together and help us to direct where we're going. We are moving into a more limited but continuous search and rescue effort. We really appreciate the outpouring of support that's been from the community, from the family, and everything that's been going on. We still need people to have their eyes and ears out there and keep working towards the goal. And our goal, which has never changed from the beginning, is to find Kiely Rodni.
And hopefully they do so. Still ahead on Law and Crime Daily, another delay in the Parkland school shooting penalty phase trial. But first, a Midwest man stands trial for the murder of his wife. This is ahead of opening statements. We take a closer look at Ohio versus Matthew Moore. Welcome back, everybody. A jury is selected and takes a trip to the scene of the crime ahead of opening statements in the Ohio murder case of Matthew Moore. Moore is charged with murder in the 2020 death of his wife, Emily Noble. Noble was reported missing on May 24, 2020, after celebrating her 52nd birthday with her husband. Hundreds of volunteers conducted search parties, but Moore reportedly never took part. In September, Noble's decomposing body was found in a wooded area in Westerville, Ohio, not far from the couple's home, with a USB cord wrapped around her neck. Now, authorities say that her death was staged to look like a suicide, but evidence pointed to a homicide. Dental records had to be used to identify the body. An autopsy revealed Noble suffered multiple facial and neck fractures. Moore was arrested 7 months later and charged with murder and felonious assault, though detectives have not announced what led them to suspect Moore. Around the same time of Noble's body being found, Moore appeared on the Vanished podcast with Melissa Jones, telling his version of the events the night his wife disappeared, but he got several details clearly wrong.
She went missing Labor Day, Monday. That's when I noticed that she wasn't there, and I called the police. There's not a lot I can say. It's unfortunate that I've been put in a position where I can't talk about specifics. If you know anything about it, and that's really super unfortunate. And I want people to know that I've been forced into this by people that I don't even know how to just really describe it. It's not, other than I can tell you when she went missing.
But Emily didn't go missing on Labor Day or anywhere close. She disappeared on Memorial Day weekend, perhaps an innocent confusion. But she was last seen on May 24th, her birthday, and the day before Memorial Day. Is it possible Matt was confused or nervous about speaking with us? It's certainly possible. And some of Emily's friends pointed out to us that Matt can come across as socially awkward. And they believe it's likely due to the brain injury he said he received as a teenager. But the conversation continued to take a strange path.
I'm really apprehensive of saying something that they could use against me. Just know that I feel uncomfortable about sharing anything because of what my professional people that are helping me with me told me, which I feel horrible because I can't help. I can't help find my wife.
Opening statements are set to begin Wednesday morning, and you can watch the Law&Crime Network for gavel-to-gavel coverage. So, Bernarda, as a former homicide prosecutor, how do you prove that a murder was a staged suicide?
So in focusing on this case, your key witness in this case is going to be the coroner. It's going to be the medical examiner, because the medical examiner and the coroner is going to be able to explain to you what was the cause of death. What type of injuries did she have? How could she have encountered these types of injuries? And then take it from there. I believe in this investigation, the coroner's report was also sent to a strangulation expert who was able to say, hey, she didn't die as a result of strangulation, and that instead it was something else, and that we're ruling this a homicide. So you use your medical examiner, and you also use the funny facts in the sense of things that don't make sense of what Mr. Moore was saying throughout this.
Yeah, it's a unique case. And Philip, I'm going to look to you for the defense. If Moore was your client, how would you tackle the case?
Well, first of all, like I tell all clients, keep your mouth shut. Let's be honest, podcasters and producers are not your friend when you're under investigation. And especially if you're socially awkward, you should keep your mouth shut. But having said that, he was an unscripted grieving husband. This was very unrehearsed. It was very spontaneous type behavior. I would try to put on an alibi for him. Where was he? Can anybody corroborate where he was at the time? And when her body came up missing, did he have any injury? Was there any forensics? Was there anything maybe on Google searches, on his cell phone? Did they have a motive? And I would highlight the absence of all of that.
I don't know. You both have laid out some pretty good points for both sides, so I'll be curious to follow this case because it is a bit unique. Coming up on Law&Crime Daily, the Parkland school shooter penalty phase trial. Does the defendant really understand the terms of a future sentence? Plus, the wife of late basketball star Kobe Bryant takes on Los Angeles County, and we take a closer look at the civil case. Welcome back, everybody. Another delay in the Parkland school shooter penalty phase trial as a status hearing is pushed from Tuesday afternoon to Wednesday. Now, this comes just one day after the defense unexpectedly canceled a Daubert hearing, saying it would not present evidence on issues that were addressed by prosecutors. Judge Elizabeth Schurer set aside all week for the hearing, which was expected to touch on the defendant's recent brain scans. Last October, the shooter pleaded guilty to 17 counts of murder and 17 counts of attempted murder. He now faces life in prison or the death penalty. But according to a report obtained by the Associated Press, the shooter seemingly disagrees. The report, made by a mental health professional hired by the defense, details the defendant's delusional belief that he will be released, saying it's his life goal to help people. This report echoes statements made by the defendant when he pleaded guilty.
I am very sorry for what I did, and I have to live with it every day. And that if I were to get a second chance, I will do everything in my power to try to help others. And I am doing this for you, and I do not care if you do not believe me.
Phase 2 will be life in prison, meaning life with no parole. There's no parole in Florida, you understand?
I understand.
Do you understand that in a lot of states, life means life, but in 25 years, they'll consider you for release? Do you understand?
understand.
But Florida, we do not have that. Life means you are in there for the term of your life and you do not come out until you are no longer alive. Do you understand?
I understand.
Philip, we heard the judge explain what a life sentence means to the defendant, and he agreed that he understood, but this new report makes it sound like that is not the case. So I'm curious, is this going to cause issues in the future?
It could. Keep in mind, Jesse, that a delusional disorder does not necessarily mean that a criminal defendant is mentally incompetent. Mentally incompetent in a non-clinical setting, such as a legal environment, just means that the defendant does not understand the nature of the proceedings and the charges, or he cannot rationally assist with his defense counsel. It sounds like he understands generally the nature of the proceedings and the charges, and he can rationally assist despite his delusional disorders. Now, he does have a fundamental right to be mentally competent throughout these proceedings. If he appears to be relapsing or decompensating to a point where he cannot rationally assist, counsel can declare a doubt, they can halt the proceedings and get him seen by a psych.
Well, I want to make a sense of this, Bernardo, because if we go to that Daubert hearing, why do you think the defense nixed the plan to use the shooter's brain scans? Is it not going to work? Were they concerned about what the prosecution might come out with?
So it's possible with the defense is that they weighed the pros and cons of having an expert testify at trial, because ultimately it would have been a battle of the experts. So the prosecution probably would have had an expert lined up to actually say that the findings of that expert that the defense was providing wasn't one that was conclusive or one that could be relied on. So instead, the defense is probably going to go with jury nullification. Just remember, they just need one juror to be able to not agree to issue the death sentence in this case, and you save the life of Nicholas Cruz.
Yeah.
But we didn't hear an opening statement, so who knows?
And you know what? A jury might just look at this and say, we've lost so many lives, we can't lose another one. And we've seen that happen in other cases before, but we'll continue to follow it. When we come back, the widow of basketball great Kobe Bryant takes on Los Angeles County. We head to California for the latest developments in the civil trial. And welcome back. A medical examiner rules that the deadly shooting on the Rust movie set was an accident as actor Alec Baldwin discusses the shooting on a popular podcast. In October 2021, actor Alec Baldwin held a prop weapon as he rehearsed a scene for the movie. The gun, which was loaded with live ammunition inside, went off. Cinematographer Helena Hutchins was shot and killed, and director Joel Souza was injured. As Law&Crime Daily has reported, the FBI conducted an accidental discharge test determining that the gun could not fire without the pull of a trigger. But while appearing on Chris Cuomo's podcast this week, Alec Baldwin doubled down on claims that he never pulled the trigger. Baldwin said, quote, "The only question here is who put a live round in the gun." So far, no criminal charges have been filed. And also in celebrity news, Tuesday marks day 6 of the civil lawsuit brought on by the wife of late basketball star Kobe Bryant against Los Angeles County. Vanessa Bryant, wife of the late basketball star, brought the suit against Los Angeles County after officials shared photos of the deadly helicopter crash that killed her husband, daughter Gianna, and 7 others. Bryant argues that first responders took graphic photos at the crash site and then shared them with others outside the police and fire departments. Law&Crime West Coast reporter Megan Cuniff has been inside the courtroom every day during the trial. At the center of Tuesday's testimony were the photos of the crash site shown to a California bartender. Last week, bartender Victor Gutierrez testified, saying a Los Angeles County Sheriff's deputy showed him photos of the wreck, but he denied that the pair laughed about the photos, saying, quote, "That would be psycho." Cuniff says jurors heard from the deputy himself on Tuesday and learned that the crash scene photos were also sent to other officers while playing video games together. Unbelievable. Now, Philip, you're the deputy public defender in LA County. What has been the response there about this case?
Well, first of all, to be fair to Mother County, if you have employees who are engaging in this type of behavior, they are acting outside the scope of their employment by sharing photos to non-government employees who have absolutely no bearing or relationship to the investigation. So therefore, I don't believe the plaintiff should be able to reach into the deep pockets of Mother County. Now, it's not to say that they don't have some evidence of a policy on the part of the county, but I believe the record is devoid of that. Unless the plaintiffs can point to some trend or other instances where county officials kind of cast a willfully blind eye or look the other way regarding similar past behavior with gruesome photos, then maybe. But up to this point, this appears to be an isolated aberration. Therefore, Mother County should not be on the hook.
Well, I hope you're right, because these allegations are pretty disturbing. I mean, for this case, Bernard, what sort of outcome would you expect for the case? I mean, do you expect it to go in favor of Bryant or LA County?
It's going to be very difficult to decide that, because if you try to decide it in terms of emotions, your heart goes out to the plaintiffs. You would never want that a person that was killed in such a manner that there's photographs of that person's body, of what was left of that body, that's out there in the internet stream where you can't really scrub away those photographs. And you're scared that those photographs will one day be unveiled for your children to actually see. It may be for the plaintiffs, but I don't think it's going to be a large amount. If anything, possibly in punitive damage, to send a message for this not to happen again, because you're jeopardizing the integrity of future investigations.
Philip, Bernarda, excellent analysis as always. Thank you so much. And everyone out there, thanks for joining us here on Law and Crime Daily. We're going to see you next time as we discuss justice in America. See you then.